Welcome back to the Deep Dive, where we take your stack of sources, articles, statutes, legal analyses, and, well, we turn them into the most essential nuggets of knowledge you need.
Yeah.
Our mission today is a deep dive into the legal architecture of marriage and civil partnerships, specifically within England and Wales. We're going from foundational concepts all the way to recent landmark legislative shifts.
It's a journey that really shows you just how much the law actively defines and regulates relationship status. And we're dealing with some dense statutory law here.
We are.
We'll be navigating the key frameworks: the Civil Partnership Act 2004, the huge societal shift of the Marriage Same-Sex Couples Act 2013, and the very recent protective legislation, the Marriage and Civil Partnership Minimum Age Act 2022.
The goal here is to give you a clear, synthesized map of what these legal unions actually represent today.
Exactly.
And when you look at these sources, what becomes really clear is that the law is, constantly struggling to balance two things: individual freedom to choose who you love, and the state's need for societal stability and protection.
That tension is everywhere.
It defines everything we're about to cover. So let's start with the most fundamental concept, the very core of this. If we strip away the white dress and the confetti, what is marriage, legally speaking? You hear it called a contract, but is it really?
It starts as one, yes. English law defines marriage as an agreement between two people to enter into a certain legal relationship.
Okay.
So in that sense, the agreement to exchange mutual rights and duties, it absolutely has the hallmarks of a contract. You are agreeing to a lifelong partnership.
Right. Let's unpack this, because this is the first major aha moment for anyone trying to understand this. The moment a marriage goes beyond being just a simple contract.
Yeah.
What sets this agreement apart from, signing a tenancy agreement or selling a product?
The differences are what truly flip the script. In a commercial contract, the law is mostly just concerned with the two parties agreeing on the terms. In marriage, the law dictates the vast majority of the terms. You can't just write your own marriage rules. First, the law on capacity is unique. It's not just about being an adult, but also about the mental ability to consent. Second, you have to follow special, often elaborate legal formalities. The ceremony itself.
And the termination rules are what really underscore the state's involvement.
Precisely. Unlike a voidable commercial contract, where a party could just decide to rescind it if there was fraud, a voidable marriage needs a formal court nullity order to be set aside.
A court order.
And critically, you cannot simply discharge a marriage by mutual agreement, frustration, or breach. You can't just shake hands and walk away because one party broke a promise.
Right.
Outside of death, it can only be terminated by a formal public legal act like divorce, dissolution, or nullity. The state basically maintains the ultimate veto over dissolution.
That makes perfect sense. So the contract is merely the doorway into something much bigger, which is the legal concept of status. Marriage grants a status. What does that term mean in, tangible day-to-day legal reality for you, the listener?
Status is the powerful legal architecture that surrounds you once you step through that contractual doorway. It means you belong to the married persons class, a class to whom the law assigns peculiar legal capacities or incapacities.
So peculiar legal capacities.
Essentially, the law fixes a whole set of rights and obligations onto you, regardless of what you two might have agreed upon privately.
So if the law dictates the duties, and they're fixed by Parliament, things like automatic next of kin status, joint tax assessments, or the right to claim maintenance upon separation, what's the point of a prenup? Does the contract part become mostly ceremonial if the status overrides everything?
That's a really sharp question. The contract aspect ensures validity, but the status is the substance. A prenup doesn't override the fundamental duties of the status, but it can influence how the court exercises its discretion on finances when you dissolve it.
Okay.
So you can agree on how property might be divided, but you can't contract out of your right to spousal privilege in court or your right to a share of an occupational pension. The legal status provides the floor, the baseline, which can't be undercut by a private agreement.
That distinction really brings to life why the historical political argument was so strong. Advocates for same-sex marriage fought so hard for the status of marriage, even when civil partnerships already gave them functionally similar rights.
Exactly.
It wasn't just about the rights, it was about achieving true equality and legal classification.
Absolutely. It was seen as a matter of substantive equality. Being in a different legal class, even one with similar rights, was viewed as a form of, discrimination. The legal status itself held significant moral and social weight.
Okay, let's shift gears entirely now. moving from the definition of status to the law's role as a protector. We're talking about the most significant recent reform, the Minimum Age Act.
The Marriage and Civil Partnership Minimum Age Act. It came into force on February 27, 2023. This legislation fundamentally raised the age at which anyone can legally marry or enter a civil partnership in England and Wales to 18 years old.
This sounds simple, but the immediate impact is massive, isn't it? It completely removes the old provisions that allowed 16 and 17-year-olds to marry with parental or judicial consent.
All gone. No consent, no exceptions below 18.
And the stated purpose is crystal clear.
It's about protecting children from forced marriage. The sources emphasize that while it's a huge shift, the act isn't retrospective. So if you were legally married at 16 or 17 before February 2023, your relationship is still valid.
Now, when we look at the data that supported this change, the sources give us a really complex picture. The official ONS figures from 2018 suggested very few registered marriages. Only 0.06% involved 16 or 17-year-olds. I mean, that number seems incredibly small.
It does, but that number is highly deceptive.
How so?
As the sources stress, those statistics only cover legally registered ceremonies. They completely exclude non-registered religious ceremonies, which is where the risk of forced marriage is so often hidden. That's why you have to look to the forced marriage unit data to get the true picture.
And the FMU figures are pretty sobering.
They show the gravity of the issue. In 2020, the FMU supported families in 759 cases related to possible forced marriage, or FGM. And when you drill down into those forced marriage cases, a significant proportion, 26%, involved victims aged below 18.
Wow.
That means that for every 4 forced marriage cases the FMU handled, 1 involved a child who was legally unable to consent under the new rules. This reform directly addresses that vulnerable group.
And crucially, the FMU stresses this isn't an issue tied to any one specific culture, religion, or country. It's a method of coercion wherever it occurs.
Absolutely. And the Minimum Age Act tackles this head-on by creating a severe legal deterrent. It doesn't just change the consent age, it expands the legal protection by making it illegal for any person to arrange the marriage of someone under 18 in England and Wales.
So it criminalizes the act of arranging it.
Yes. This substantially expands the scope of existing forced marriage legislation. It provides a much stronger safety net.
It's a comprehensive approach to prevention, then. It is worth noting the contrast with the UK's devolved nations, though.
Yes, that's important. The minimum age of 18 applies only to England and Wales. If you're in Scotland, you can still marry or form a civil partnership at 16 without any need for parental consent.
In Northern Ireland.
In Northern Ireland, you can marry at 16, but you still need to get parental or judicial consent if you're under 18. The laws vary significantly even within the UK.
Let's transition now from protection to the long march toward equality and status, looking at the evolution of these unions since the millennium. Let's start with the Civil Partnership Act of 2004.
The 2004 Act was a landmark piece of legislation. It established the civil partnership, initially solely for same-sex couples, granting them rights and responsibilities nearly identical to those of marriage. We're talking tax, pensions, inheritance, parental rights.
And they can only end in the same way.
That's right. Death, dissolution, or annulment.
The actual ceremony is where the fundamental difference lies, right?
That's the key procedural difference. While marriage involves a verbal contract made during a public ceremony, a civil partnership is formed by the couple signing a legal document, a schedule, in front of a registrar and 2 witnesses.
So it's more of an administrative act.
It is not a ceremonial vow, though many couples choose to have a ceremony afterwards. The legal status it confers, however, is almost identical.
And that setup eventually paved the way for the Marriage Same-Sex Couples Act 2013. The political goal there was really complex. Make same-sex marriage lawful while at the same time protecting the religious freedoms of groups that opposed it.
It was a monumental balancing act. The 2013 Act achieved several key things. Most importantly, it enabled same-sex couples to marry in civil ceremonies. It also offered ways for existing civil partners to convert their partnership to marriage.
And it had that crucial reform about gender recognition.
Yes, it enabled individuals to change their legal gender without being forced to end their existing marriage. A huge reform.
The political sensitivity around religious freedom led to that famous quadruple lock protection built into the act. This was clearly essential to getting it through Parliament.
Oh, without that robust protection, the bill likely would not have passed. The quadruple lock ensures that no religious organization or any of its representatives can be forced to marry a same-sex couple.
So it's a total opt-in system.
Exactly. A religious same-sex ceremony is only legally valid if the religious body has explicitly opted in, if the minister is personally willing, and if the premises are registered for that purpose.
And it goes further, providing specific legal immunity.
It does. It amends the Equality Act 2010 to confirm explicitly that it is not unlawful discrimination for a religious organization or its representatives to refuse to conduct a same-sex marriage. It shields them completely.
And what about the Church of England?
It protects them specifically. It addresses the Church of England and Wales's unique common law duty to marry parishioners, making sure that this duty does not extend to same-sex couples. It maintains their internal canon law while allowing civil law to advance.
What's fascinating is that even after this landmark law passed, it mandated legal reviews, basically acknowledging that the fight for full legal equivalence wasn't quite over.
No, it wasn't.
What were those reviews targeting?
3 critical areas. First, a review into whether non-religious belief organizations, like humanists, should be able to conduct legally valid marriage ceremonies.
Because they can't at the moment.
Correct. Their ceremonies aren't legally recognized. Second, a review of the operation and future of the Civil Partnership Act itself, asking what its long-term purpose is now that marriage is available to all.
And the third review addressed a crucial technical disparity.
Yes, the third focused on addressing historical discrimination in occupational pension schemes, specifically differences in survivor benefits for same-sex couples.
Right.
It just highlights that achieving status is one thing, but making sure decades of accrued rights are truly equal requires meticulous legal adjustments in these other areas. It's the long, necessary tail of equality legislation.
Now let's shift gears one last time to discuss how these statuses formally end, specifically annulment or nullity. This is often misunderstood, I think, maybe because it's just so rare compared to divorce.
It's fundamentally different. Divorce accepts the marriage was valid but is now broken. Annulment says that due to some major flaw, the marriage should be treated as if it was never legally valid in the first place.
And it is incredibly rare.
It is. The sources show in 2021 there were only 231 annulments in England and Wales, compared to over 80,000 divorces granted in 2022.
That scarcity tells you the legal bar is extremely high. So, for the listener trying to grasp this, we need to clarify the central distinction between a void marriage and a voidable marriage.
Think of it this way. A void marriage is like trying to pay for something with counterfeit money. It was never valid, legally speaking, from the get-go.
Because of some fundamental flaw.
Yes. Annulment isn't technically essential, but it's highly advisable to get a court declaration for legal clarity, especially if you want to remarry.
And avoidable marriage.
That's like a transaction that was valid when you signed the paperwork, but it meets a specific, serious criterion that allows it to be legally unwound and set aside by a court order. It was a real marriage until the court formally undoes it.
Okay, let's detail the absolute non-negotiable grounds that make a marriage void. The counterfeit money reasons.
They are the basics of validity. You were already married or in a civil partnership with someone else. You are too closely related, within the prohibited degrees of relation. Or, crucially, either of you was under the age of 18 at the time of the marriage.
And that's because of the 2023 Act.
Exactly. The old grounds for 16-year-olds needing consent are now obsolete. Any attempt by an under 18 to marry today just results in a void marriage.
And then we come to the grounds that make a marriage voidable. These are the circumstances that allow a valid relationship to be undone, and some of them are quite surprising.
They often revolve around a lack of true consent or serious non-disclosure. Lack of proper consent is a key ground, covering forced marriage or being mentally incapable of making the decision.
Right.
Then you see criteria tied to health or knowledge at the time of marriage. The other party was suffering from a sexually transmitted disease, or the other party was pregnant by someone else.
That last one pregnancy by someone else, that really connects back to the historical concept of marriage as a structure for legitimate procreation, doesn't it?
It does, and that historical view explains the inclusion of the final 2 criteria, which are perhaps the most surprising to modern listeners: non-consummation and gender transition.
Let's take non-consummation.
It's a ground for voidability if it's due to the physical incapacity of one party or the willful refusal of sexual intercourse by the other.
And the sources specifically note this ground does not apply to same-sex couples. Right.
That is explicitly stated in the legislation. This exclusion sort of implicitly acknowledges the historical link between non-consummation and the state's traditional interest in procreation within marriage, an interest that is, by definition, redefined in same-sex unions.
And the last one.
Finally, if one party is in the process of transitioning to a different gender, that also makes the marriage voidable, requiring the parties to decide whether to continue the union or dissolve it.
So we've traced this incredible legal journey. We started with the philosophical tension between contract and fixed status, moved through the protective measures of the Minimum Age Act, achieving equality through the 2013 Act, and finally detailed the very specific boundaries set by nullity law.
What this all shows is a legal institution that's constantly trying to update itself while holding on to this core concept of status. It's a balance between individual freedom and the need for societal structure.
It's an institution that has been forced to evolve so dramatically over the decades, from recognizing non-Anglicans to seeing women as equal partners before the law, and now extending that status equally to all couples regardless of sex.
And given that continuous evolution we've seen, and the fact that the 2013 Act mandated ongoing reviews about belief organizations like humanists and the very future of civil partnerships, here is a final provocative thought for you to mull over.
Go on.
If the fixed legal status of marriage continues to be stretched and modified to accommodate almost every form of adult-loving partnership, how much further can that definition evolve before its core function as a unique, state-defined entity changes entirely?
A question that is truly still being answered by both Parliament and the courts. Thank you for sharing your sources and letting us take this deep dive into the structure of marriage and civil partnerships in England and Wales. We'll see you next time.